Good afternoon, everybody. Thanks for attending our talk today. This is Did We Get the Upgrade? What you need to know following the overhaul of Canadian trademark law, which will be presented by our panelists from Marks & Clark. As you may know, oh, I lost the screen, sorry. As you may know, this is Marks & Clark's 100th anniversary in Canada. So we have quite a bit of programming this year. We're a small firm, but we're powered by large global resources. We have 18 offices across the globe and handle significant international work. And in Canada, we've been providing high quality IP services for over 100 years. I'm sure everyone's very used to Zoom meetings and webinars by now, but just a few housekeeping notes. All the attendees, your lines will be on listen mode, and the event will be recorded. If you do happen to have any technical issues, first try refreshing the page. And if the issue persists, you can contact it@marks-clark.ca, and somebody will help you there. Everyone, of course, is muted, but to ask your question, please just hover over the Zoom window toolbar and put your question in the question and answer box. And we'll handle quite a few questions at the end, hopefully, depending on time. There's obviously a lot of content. Just in terms of viewing, the easiest thing to do is probably put it to your settings to fit to window. But of course, it's up to you. First, I'll introduce our panelists for today. Catherine Lovrick, Sanjuk Datol, and Nathan Fan. Kat's a lawyer and trademark agent at Marks & Clark and a partner. She advises on trademark clearance and protection, as well as rights acquisition, licensing, and enforcement. She manages large international trademark portfolios and has coordinated global enforcement and anti-counterfeiting programs. Her expertise is broad and covers many industries, including creative and emergent tech, retail, fashion, food. And her clients range from multinational companies, Canadian companies, crown corporations, startups, and as well as individual artists. Kat's practice includes a lot more than trademarks law, copyrights, personality rights, publicity and moral rights, as well as marketing, data protection, and privacy law. Sanjuk is a partner in the Marks & Clark office in Toronto and trademark agent as well. She advises a range of clients on management of intellectual property portfolios, focusing on trademarks. She handles all aspects of trademark prosecution from start to finish, as well as management of trademark portfolios. She also focuses on enforcement, including trademark and copyright matters, as well as domain names and many internet-related disputes. Nathan is a lawyer and trademark agent and a partner at Marks & Clark. His practice focuses on the acquisition, enforcement, and commercialization of intellectual property rights. He advises on all manners of trademark prosecution and global trademark portfolios. He also deals with commercial agreements involving intellectual property rights. Nathan regularly appears before federal and Ontario courts, as well as the Canadian Intellectual Property Office and Trademarks Opposition Board. And with that rather lengthy description, I will hand over to Kat to start her presentation.
Thank you so much. And Sebastian, you also deserve an introduction. So Sebastian's our moderator today. He's an associate with the firm and a brilliant shining star, and no doubt will have a bright future. I will now request remote control and hopefully, well, great. So bear with us. There may be a little bit of a lag as the slides move through. So to begin, since this is a legal presentation, a disclaimer seems like a natural place to start. Nothing in this presentation should be taken or relied on as legal advice. So this presentation does not form a solicitor-client relationship with anyone attending this call. Any views expressed are personal, so please blame us personally. They don't necessarily reflect those of our firm or our clients. Any unauthorized use or reproduction of this presentation is prohibited. So in terms of what we'll be talking about today, we'll do a general overview of changes to Canadian trademark law. I will start off discussing simplified Canadian trademark filings, the impact of the Madrid Protocol being implemented in Canada. Senjukta Tol will then discuss NIS classification, distinctiveness objections, as well as the impact of COVID-19 on trademark practice in Canada. And we'll close with Nathan Fan walking through changes to opposition and cancellation proceedings before the federal court. So without further ado, let's start with simplified trademark filings. So as anyone that is filed in Canada recently will know, there are no more filing grounds. They are not required. You do not need to go through the exercise of gathering use and proposed use claims. So for any foreign associates or direct clients that look back to the times working with their marketing departments to pinpoint the earliest date of first use, or to be confident that there wasn't in fact use if you were going to rely on proposed use, that is no longer the case. This provides an opportunity. It's a good time to review Canadian trademark filings because use is no longer required to secure a Canadian registration, to consider whether or not there are gaps owing to previous use requirements in Canada and whether or not it's appropriate to fill those gaps based on a good faith intention to use. While use is no longer required and filing grounds related to use are no longer required, there must be a good faith intention to use the mark in Canada. So soup to nuts or kitchen sink filings are likely to still create risk. Nathan, a little bit later on, will talk to us about bad faith filings and round that out a little bit more. In terms of our simplified filings, we have seen per class fees are now in play. There was a 2% increase. So for the first class, it's now $336.60 and $102 for each additional class. Those are the government fees. CIPO reserves the right to increase fees going forward. So we may see these somewhat odd numbers on a go forward basis. So what is required to file? First, you need the identity of the applicant, the full name and postal address of the applicant. And it's important to keep in mind that the applicant must be a person, and that includes individuals, partnerships, trade unions, associations, joint ventures, or corporations. In Canada, 2 or more persons who by agreement do not have the right to use the trademark in Canada, except on behalf of both of them, are also entitled to file. Although care should be exercised whenever filing outside of a formal legal structure like a joint venture. You also need to provide a representation and a description of the trademark, or a description of the trademark. So words in standard characters are now, you can file in words in standard characters. You can also file design marks. In terms of design mark filings, when you instruct Canadian Counsel for a design mark, it is important to keep in mind now that if you want to claim color, the visual representation provided should be in color, and likewise in black and white, the representation must be in black and white. Color descriptions in Canada are generic code names, color names rather, and you can supplement with reference to a color identification system. I'll discuss in a moment non-traditional marks, and for now I do note that in terms of a representation of a sound mark, CIPO will accept or requires an MP3 recording, and it must be less than 10 megabytes in size. So as you're likely aware, Canada introduced non-traditional marks, and when you're filing, you do need to indicate the type of mark. So you can have a certification mark, and in terms of recent updates to Canada's certification marks, it used to be that you needed use of the certification mark prior to filing in Canada, with use-based filing grounds being done away with. That is no longer the case. You can now file a proposed use certification mark in Canada. And as mentioned, Canada now also provides for non-traditional marks. And while we await a critical mass of applications to get a better sense of exactly how CIPO's practice will be implemented, CIPO has provided a practice notice in some direction on descriptions for non-traditional marks. So for example, scent, the trademark is a coconut scent diffused throughout a retail store setting. Texture, the trademark consists of the waffle type texture as applied to the surface of toilet paper as depicted in the visual representation. Position marks, the trademark consists of the position of a V-shaped stitching design as applied to a pocket as shown in the visual representation. The pocket shown in dashed outline does not form part of the trademark, but is included merely to show the position of the trademark. And the practice notice sets out other examples of descriptions for other types of non-traditional marks. So while trademark filings are in fact have been simplified significantly, Canada does continue to take a very particular approach to goods and services specifications. As you're likely well aware, goods and services specifications need to be in specific ordinary terms. So first, in terms of specific, the Canadian Trademarks Office applies a three-part test, and basically the Trademarks Office looks to see whether or not the goods and services are described specifically enough to assess whether or not, first, the mark is clearly descriptive or deceptively misdescriptive of the goods and services. Second, to ensure that there's not, or to prevent an unreasonably wide ambit of protection being afforded to the mark. And third, to enable the office to assess confusion with prior marks. And then the other part of the test is whether or not the goods and services are in ordinary commercial terms. Generally speaking, the office will look to similar language and scope having been used by others in the same industry to describe the applicant's goods and services. And if no ordinary commercial term is known or can be demonstrated, the description must be clear and concise. And technical, lengthy, or ambiguous descriptions of the characters of goods and services are not acceptable. And as Sanjukta will discuss, goods and services do now need to be grouped according to the NICE classification system. Oops. Sorry, I'm trying to go back. Bear with me. Given our particular approach to goods and services descriptions, we thought we'd do a quick do's and don'ts. In terms of do's, do reference the Trademarks Office's Goods and Services Manual and aim to use pre-approved terms at the outset. That said, don't be angry if you do undertake that exercise, and by the time the application is actually examined, the goods and services that were previously deemed to be approved are no longer approved. The Goods and Services Manual is a live document. It is constantly changing and being improved and updated. And sometimes certain acceptable terms are retired from the manual. And while that can be a point of frustration, which is recognized by clients, it's still better to, if you can, start with a good examination of whether or not the goods and services are likely to be acceptable. Don't use or and or, that will almost invariably trigger an objection. Avoid using non-exhaustive lists. So words such as including, such as, and the like, and similar goods related services are likely to trigger an objection. Don't include advertising, promotion, and marketing unless the services are for the benefit of a third party, and consider saying that expressly. Don't characterize intangibles as goods. So for example, websites, electricity, domain names, waste, gas, and steam are all considered services. Do use namely and in the nature of to further particularize goods and services descriptions. Ensure that you further specify goods such as software, pharmaceuticals, accessories, equipment, apparatus, and systems. Those categories will invariably or nearly invariably raise an objection for further specification. Be very careful with semicolons versus commas. For example, if you're including parts and fittings within a particular specification, do not separate parts and fittings from the goods and services, or the goods for which the parts and fittings are for, by a semicolon. Use a comma instead. Be careful with parentheses, and as Sanjukta will discuss, do classify your goods and services. Oh, apologies, I am again one slide too. Sorry. In terms of Madrid filings, Canada did recently join the Madrid protocol. And I'm trying to get to the initial slide. Thank you. Which means that now, and this has been a welcome change for both Canadians as well as foreign filers or foreign trademark owners, looking to cost effectively file in multiple foreign countries at once. Basic applications can be filed through Canada as the office of origin. If you're not a resident or Canadian entity, you must have a real and effective commercial establishment in Canada. If you are using Madrid or generally filing internationally, given Canada's outbound filings really seem to, after the US, target Europe and China, I will flag it's important to keep in mind that the UK, Switzerland, and Norway are not part of the EU, and applications, to the extent that you want to cover those jurisdictions, should be filed separately in those jurisdictions. Likewise, if you're filing in China, it's important to keep in mind that Hong Kong, Taiwan, and Macau are not covered by your Chinese national filings. And it's also important, and this is, I suppose, more for Canadians that are less familiar with the Madrid system, that not all countries participate in Madrid, and national files may still be required if you're undertaking a broad global filing program. So for example, Hong Kong, Taiwan, South Africa, several South American countries such as Chile and Argentina, Saudi Arabia, United Arab Emirates, Dubai, and Jordan are not members of the Madrid Protocol. And finally, it's important to keep in mind that while Madrid does avoid formalities and affords cost savings at the front end, if an office action is issued, a local agent may generally be required. And in many countries that will still involve the requirement for a power of attorney, which sometimes does need to be notarized or legalized, and that can increase costs. So in terms of the uptake of Madrid filings to date, so far we've seen Canadians starting to use the system, not yet in droves, but starting to use it. There's been 889 applications filed through Madrid to date. This is based on the WIPO database, so there is a lag between when a Canadian files through the Canadian office and when WIPO receives notice, so it's possible the number's a little bit higher right now. And in terms of foreign filings designating Canada, there have been 33,000 and just over 33,000 filings to date through the Madrid system that designate Canada. And the numbers sort of roughly track out to about 20,000. In 2019, we only joined in July, and we had 10,000. In 2020, we had 20,000 so far, and to date, we have about 2,000 in 2021. In terms of the filers, US is the biggest adopter in terms of designating Canada to date. And then next is European countries, Germany, US, UK, France, Germany, UK, and France, and then China. And on the screen, you can see sort of a rough bar chart showing the different filings. So in terms of Canadian practice and a few practice points for Madrid, first, it's important to keep in mind and to be aware that the Canadian Trademarks Office will not correspond with foreign agents. The Trademarks Office will send a courtesy letter to the WIPO agent suggesting that they appoint a Canadian agent. Second, in terms of practice, 10 months after the Canadian Trademarks Office has received the designation, which is about 20 months after the filing in WIPO, the Trademarks Office will issue a notice of possible opposition. This does not mean that an opposition has been filed, but rather as a preservation of rights to issue a refusal based on an opposition after the 18-month time limit. Third, the Trademarks Office must issue refusals based on examination within 18 months of when SIPO is notified of the designation. As I mentioned, that's about 21 months from filing. Adhere, in view of the approach to goods and services, in many, if not all cases, there will be at least a technical objection. And in terms of timing, we flagged that we have noticed that WIPO is issuing the OA to the WIPO agent before the domestic Canadian agent has actually received an office. The office action, a copy of the office action. So if you're a foreign agent and your Canadian agent hasn't reported an office action, it may be that you received it before them. The Trademarks Office is aware of the issue and trying to work on it. And in the meantime, please be kind to your Canadian agents if WIPO does inform you of an OA before we've reported to you. And we're also noticing in terms of Madrid filings that an examiner's report is typically technical and is currently stating that further examination will follow. It's a little early to tell, and it remains to be seen to what extent we're likely to see piecemeal examination as a practice rather than an exception when it comes to Madrid filings. The Trademarks Office is well aware that piecemeal examination can be frustrating. I'll pause for a moment to note that the current examination timelines for domestic applications are approximately 24 months, if not greater, from the Canadian filing date. And as a result of that, foreign applicants, given the 18-month window which is really 20 months for SIPO to examine, foreign applicants may actually wind up seeing their applications examined sooner than domestic applicants. And likewise, the flip side of that is that Canadian applicants that use the Madrid system to file abroad may face considerable delay before they know how the nature of examination in Canada will go and whether they will face an opposition. And the delay in getting to registration in Canada can be a challenge for Canadians filing IRs. and having comfort surrounding low risk of, surrounding there being a low risk of central attack. The Trademarks Office is very much aware and working on improving its processing times, and it's undertaken several initiatives, including hiring and training a team of trademarks examiners. It's also undertaken a huge project moving from paper to digitization and has made tremendous progress in digitizing its operations, though it still does have a way to go. A few final practice points in terms of Madrid. First, it's important to note that filing assignments through WIPO may result in the Canadian agent being revoked. The Canadian Trademarks Office is aware of this issue, but we're noting it for the time being. Filing of licenses on the International Register also have no effect, legally speaking, in Canada. With that, I will pass it over to Sanjukta to pick up with NIS classifications. Thank you.
Hi, everyone. I'm
trying to give it back to you.
Yeah. Sorry about that. So I'll be covering these classifications, the distinctiveness objection and the impact of COVID-19 on trademark practice. And we'll start with NIS classifications. As Kat mentioned, Canada has finally adopted the NIS classification as of mid-2019, and all goods and services included in an application that are either domestically filed or through the international system or the Madrid protocol must be classified. There are some things to keep in mind when you are classifying goods and services, is that the Canadian Trademarks Office, as Kat mentioned, still require goods and services to be identified in ordinary commercial terms, which in some quarters has become code for frustratingly detailed, because the level of detail required can be quite onerous, particularly for clients that are filing applications in Canada, but are based in the UK or EU, where broader terms are routinely accepted. So that can be a point of frustration for clients. The Trademarks Office has final say on classification requests with no ability to appeal that decision. In several countries, some clients will employ the strategy of including goods and services from various classes and filing under a single class initially, and then waiting for the application to move to examination before deciding which of the goods and services they want to keep. And this allows for clients to keep their front end costs low, and then but still have the option of expanding their application as they need to when the application is being examined. Now, that strategy can backfire in Canada because the Canadian Trademarks Office holds the applicant liable for all the goods and services, regardless of how they're classed, liable for all the fees, for all the classes that are covered in the original application. So this strategy of filing multi-class applications under a single class to try and save money or on official fees up front may not necessarily bear fruit in Canada. There can also be discrepancies in classification between the Canadian Trademarks Office and foreign offices. We've seen that at least initially when NIS classification was first implemented, that there was inconsistent classification as between the Canadian Trademarks Office and, for example, the US PTO, due to the different versions of NIS classification that they were each subscribing to. So there can be a level of inconsistency across jurisdictions, and that's something to keep in mind. And similar to applications, existing registrations also have to be, sorry, did this screen not? Okay. So registrations issued prior to June 17th, 2019, when the new act came into force, must also be classified. This can be either done voluntarily or at the time of renewal. If you renew a registration without classification, the Trademarks Office basically triggers a formal classification process through the issuance of what we call a Section 44.1 notice, which sets out a 6-month deadline to file a classification request. If that deadline is missed, the registration is placed in default and can eventually be expunged from the register, even if the registration has been renewed. As far as we can see, the Trademarks Office, at least based on our experience in our portfolio, we have not seen the Trademarks Office expunge any registrations yet that have missed the deadline, but the Trademarks Office does have the discretion to do so. If a classification request is filed following the issuance of the notice, the registrant is then liable for all fees associated with all the classes, whether or not the registrant eventually chooses to retain them or not in the registration. So there can be hidden cost consequences for clients if they choose to classify before they renew for multi-class registration. So that's also something to keep in mind. And based on the process, our recommendation is that you classify goods and services well in advance of the renewal. What it does is it lets you assess the number of classes and assess the costs associated with the renewal, and also gives you the opportunity to delete classes without being liable for the official fees for those classes. You also avoid the fees associated with the formal classification process. So the reporting of the section 44.1 notice and so on can be avoided. And you also avoid the impact of the delays that are faced at the Trademarks Office in processing the classification request. So for example, currently the Trademarks Office has a 6 to 8 month backlog on processing classification requests. And that's assuming you don't have objections to classifications and you don't disagree with the examiner's view of how, or the examiner doesn't disagree with your view of the classification. It is important to note that the grace period for renewal is only 6 months, but the Trademarks Office is currently taking 6 to 8 months to process the classification requests. So the earlier you start, the better. The other thing to consider too is, particularly if you're using foreign renewal agents or services, or you are managing renewals in-house, to consider classifying your portfolio in bulk. First of all, you can probably, and as we do offer, a discount on bulk classifications, but also it can avoid all of these issues with renewing registrations without classification if your portfolio is classified as a whole, and you can have comfort that that issue has been dealt with. So the next topic I want to cover is the distinctiveness for registration. The Trademarks Office, the new act that came into force in June of 2019, basically created a new objection for examiners to raise based on a lack of distinctiveness of a mark. This is a separate objection from the descriptiveness objection that already exists in the act. And the key question the examiner will ask when evaluating distinctiveness of a mark is whether it can act as an origin of source. Although the Trademarks Office has provided a lengthy list of examples of what constitutes non-distinctive marks, which I'll get into in a minute, examiners make the assessment of distinctiveness on a case-by-case basis. So the Trademarks Office has provided some guidelines around on how that assessment is made. First of all, the mark has to be assessed as a whole and with respect to the goods and services that are in the application. So it is a contextual objection. The threshold for the objection is whether the mark has at least some inherent distinctiveness versus no inherent distinctiveness. So if there's no inherent distinctiveness, the mark is not considered registrable. But if it has some inherent distinctiveness, then technically it should be registrable. And it has to be assessed as a whole. So if you have some elements of a mark that are distinctive, then the mark as a whole should be considered registrable, even if it has non-distinctive or descriptive elements in it. So these are some of the examples that the Trademarks Office has set out, and the list is actually pretty extensive. This is just a subset of the examples that are there. But these are examples only, and it is a non-exhaustive list. So as I said, that there is an evaluation of each application on a case-by-case basis. So there is some subjectivity to the raising of the objection. Certain types of marks require evidence of distinctiveness from the get-go, as they're presumed to be non-distinctive. So non-traditional marks would fall within that category. So if you're applying for, as Kat mentioned, 3D marks, sounds, scents, taste, textures, etc., you do have to provide evidence of distinctiveness in order to get the mark registered. There's no other strategy around that. Certain types of marks will automatically trigger the distinctiveness objection as well, including if a mark is deemed to be clearly descriptive or identified as a surname or having surname significance, then the Trademarks Office will automatically also issue a distinctiveness objection. So that again is something to keep in mind when you are evaluating the distinctiveness of a mark. So as I mentioned, before I get into strategies of distinctiveness objections, I do want to touch on some of the teething problems that the Trademarks Office has had around assessing distinctiveness of a mark. So I've provided two examples. One appears to be a recipe for, I want to say is soap. And another is just an excerpt or a quote that appears. And both of these marks belong to a cosmetic company that posts fairly lengthy quotes or recipes on the bottles for their products. And these have been deemed to be distinctive, which if you review the test for distinctiveness, in my view, this is not a distinctive mark because it doesn't really help identify an origin of source. However, these were permitted to enter onto the register as late as October of 2020. In contrast, we've had certain clients have objections raised where they've had a family of trademarks, sometimes up to 20 trademarks on the register that have been previously permitted to register. And then a new application for a related mark will face a distinctiveness objection. So there is some differentiation in the subjectivity, I would say, in the treatment of marks. And these are some of the teething issues we have been seeing. It's not always consistent treatment of marks in Canada. But there are some pre-filing and post-filing strategies that we can employ to avoid or minimize the risk of such an objection. So first, of course, pre-filing, you should take into account whether or not your mark is distinctive. Does it include a distinctive element, either a word or a design? In our view, or I should say in my view, a word element is sometimes more reliable. The inclusion of a distinctive word element is sometimes more reliable than relying on a design, because the examination manual does have in the list of what is considered non-distinctive marks, generic designs in a trade are considered to be non-distinctive. So for example, if you're attempting to use the design of grapes for wine, it may not be seen as a distinctive element, a distinctive design element that would permit you to overcome this objection. So in my view, a distinctive word element is usually a better bet to get over such an objection, or to avoid it altogether. The other thing we would really encourage clients to do is to speak to their marketing teams to understand how and why they landed on this mark. Oftentimes there is a double meaning or a play on words that could lead back to a question of distinctiveness of the mark within the industry. And so that is something to keep in mind. And of course, as we would always run it by your trademark counsel before you launch, so that you can actually get some comfort around whether or not such an objection will be faced. If you do get a distinctiveness objection once you file an application, there are two avenues to overcome it. The first is with written submissions, and the second would be through filing of evidence, and I'll touch on both of them. With respect to written submissions, you can argue against the objection. What the Trademarks Office has stated in their guidelines is that the examiner is required to provide the basis upon which he or she is raising the objection, and where evidence is available, to provide that evidence to the applicant so that they can address the examiner's concerns. What we have seen is that there is inconsistent quality of evidence that examiners have relied upon, and that has been a good way to tackle some of these objections, is to question the quality of the evidence that they are relying on. For example, and I've set out some examples on this slide just to give you a sense of what types of evidence examiners will rely on. So in this case, the examples that I've provided are all undated, unverified websites, potentially that do not belong to businesses that even operate in Canada. So that's been a common concern about the quality of the evidence that the examiners are relying on. One example I'd like to point out is that we were given a excerpt of a Facebook page that had absolutely no followers, no other information other than reference to the trademark, and did not indicate whether it originated in Canada. And that was seen as evidence of the mark lacking distinctiveness. We've also had cases where the applicant's own website has been cited as evidence of lacking distinctiveness, even when the mark at issue is being used as a trademark and not in a generic sense. We've also had website printouts provided that reference the mark being used by others in other jurisdictions, so having no impact in Canada, as trademarks. So again, there is a basis to really question the quality of the evidence and the quality of the basis under which the objection is being raised. And of course, you can also rely on the state of the register. So for example, our client that had multiple marks, multiple registrations for a family of marks, related marks, was one example, but you can also rely on analogous third-party marks that have entered the register. And then of course, you also have the option to disclaim your mark. But of course, it depends on what you're disclaiming and what remains. So those are some strategies on how to avoid the distinctiveness objection through argument. But if you can't overcome it by argument, or you know your mark is not distinctive, then the option you have is to file evidence of distinctiveness. Now, the Trademarks Office has said that the burden of proof is the standard of proof that you need is demonstrating acquired distinctiveness of the mark as of the filing date. So if you have a mark that you've applied for that before you launched, then this option of overcoming objection, the distinctiveness objection based on evidence, is not available. And that's, again, something to keep in mind. You typically require about 5 years of pre-filing evidence. And the more extensive it is, the better. You have to show use and sales for each of the goods and products, goods and services in your application. And you also have to demonstrate sales in every province in Canada in order to get a Canada-wide registration, or you risk having your registration be limited only to those provinces in which you can demonstrate acquired distinctiveness. So that the amount of time and expense that's associated with filing this type of affidavit evidence is quite high. And so when embarking on this, you really have to be sure that you have the relevant evidence required. You know, there's some question on our end as to whether this level of proof is actually needed to overcome the objection, because as you will recall, the distinctiveness objection really is whether or not the mark has some level of distinctiveness. It's not whether it's well known in Canada. So the level of evidence that's required could be lowered over the course of time, but only time will tell when such questions get raised before either the trademarks office or the courts. Lastly, I just wanted to touch on the impact of COVID-19. Who has it not impacted, really? But the trademarks office the COVID had a significant impact on trademark practice in Canada, both good and bad. At the start of the pandemic, as of March 16th, 2020 to August 31st, 2020, the trademarks office actually suspended all of its deadlines, and which resulted in significant added delay to the processing of applications. One of the silver linings of COVID from a trademark perspective was that it really forced the trademarks office to move to a more electronic mode of correspondence. So where correspondence was previously required to be filed in paper can now be filed online, and the trademarks office has made great strides in updating their portal and permitting various things like recordal requests, changes of agent, etc., to be provided to them online now. The trademarks office also introduced in the fall the availability of amendment by phone. So if an examiner was raising technical objections, minor objections or corrections that were required to an application in order to get it published, we could address them over the phone. One of the issues when they first introduced telephone amendments was there was a 72-hour turnaround time, which of course, if you have clients living in other jurisdictions or multiple parties involved in the prosecution of trademark applications, then that makes that timeline impractical. But more recently, the trademarks office has provided us with 5 business days to come back on telephone amendments, and that should save considerable time and effort in obtaining registration. The other thing the trademarks office has done is introduced a practice notice on expedited examination, effective December 4th, 2020. Unfortunately, it is limited only to applications covering COVID-specific goods and services. So as Kat mentioned previously, the trademarks office is facing a delay of up to 24 months or 28 months, even in some cases, for first examination. So this practice is to allow for critical goods and services for COVID to applications covering critical goods and services relating to COVID to be processed in a faster timeline. The request that has to be made in the form of an affidavit or a statutory declaration, with 3 possible grounds for the request. One is that you have a court action in Canada, you're combating counterfeit goods in Canada, or you have Health Canada approval in hand or pending. All of this has to involve the mark that you've applied for covering the specific COVID-19 goods and services. So it is a very small subset of applications that are actually going to benefit from expedited examination. And you have to deliver the affidavit via fax or mail, which I think is not in the spirit of expediting examination, but that's a different story. And you also have to you have no guaranteed timeline. So the Trademarks Office has said that they will make every effort to expedite examination, but they haven't committed to a certain timeline. So right now, the wait time is 24 months. So are we going down to sort of 10 months or 8 months, which is still a fairly long period of time for applications to sit if they're relating to COVID? And last but not least, the Trademarks Opposition Board has also made serious strides in the light of COVID-19. They have a very helpful FAQ page that is regularly updated, and notices are sent to the profession that things have been updated. They have created special extensions of time relating to COVID-19 circumstances and dispensing with the requirement of consent from the other side, which is often needed, particularly in opposition proceedings. They've also, like the Trademarks Office, introduced more means of filing things electronically, including the evidence written submissions, as well as requests for oral hearing. And most recently, I think it was last week, it now permits electronic service on the other side using the Trademarks Opposition Portal, which for us is very exciting. Although I don't know what that says about my personal life, but anyway, that was an exciting change for me. And then also strides have been made in changing the practice around cross-examinations and hearings. And I'll let Nathan speak on that topic. So over to you, Nathan.
Thank you, Sanjukta. I'm just going to try to take control over the screen here. But while I do that, I just wanted to welcome everyone. Thank you for attending. As noted earlier, I'll be speaking about the upgrades to the opposition and cancellation proceedings and practices, and essentially how they've sort of played out over the past couple of years. And I'll also speak quickly about some of the changes that are still to come regarding opposition and cancellation proceedings. I'll also switch gears then and then speak about upgrades to general legislation, law, and practice regarding more generally trademark enforcement and federal court proceedings and how those have played out. But given the timing and the scope of our presentation, those will largely be limited to sort of the upgrades that have been put into place over the last couple of years of trademark law. I believe we will be putting on another webinar in the future regarding sort of more in-depth litigation and trademark enforcement before the federal court. So please stay tuned for that if you're interested in that. Just trying to see if I have control of the screen right now. Seems to be a bit of a lag. Oh, there we go. So first thing regarding opposition proceedings, as you may know, there have been some changes to the grounds on which you can oppose an application. With respect to the core group of grounds, those have largely remained the same. You are able to oppose on the basis that the trademark is not registrable. For example, the mark is confusing with an already registered mark, or that the applicant is not the person entitled to registration, for example, confusing with a mark previously used in Canada, or a pending application, and that the trademark is not distinctive. So those still remain the same. There have been some enhancements, for example, with the not registrable, there have been other types of prohibitions that have been expressly added to that. One new ground relating to this is for Madrid protocol applications, where a ground exists where if the goods and services specified in the application are not within the scope of the original international registration, that would be a new ground of opposition. There are also several technical grounds of oppositions, and those have also largely remained the same. I do want to note that the NIS classification requirements, as was mentioned by Kat and Sanjukta earlier, those are now mandatory in Canada for applications. However, those do not form grounds of opposition. So despite being required to comply with NIS, it is not a technical ground on which you can oppose an application. And as mentioned earlier, we've now have streamlined applications where the use claims are no longer required for those applications. So coinciding with that, those no longer will be relevant grounds of opposition. Any applications that have been advertised after the coming into force in June of 2019, these will no longer be available grounds of opposition. As noted earlier, one of the somewhat new changes is that good faith is now more clearly a requirement for the applications. And now bad faith is now an express ground of opposition. Just noting that we previously did have a sort of way to oppose somewhat on the grounds of bad faith. There was a ability to oppose on the basis that the applicant falsely or was not satisfied that it was entitled to use the mark in Canada. That is a statement that all applications used to have to check off when they were applying, and you could try to squeeze in bad faith through that. It was a mixture of whether you could prove bad faith or fraud or some sort of non-compliance with a federal statute. Unfortunately, it was never an express ground of opposition, and that oftentimes made it difficult to actually be successful in proving that during the opposition hearing. Evidence often required, for example, a documented history of the applicant trying to register other people's marks, well-known marks, and the evidence threshold was rather high to prove that. Now that we have an express bad faith ground, it's good that we have that, but there are no criteria in the updated legislation to indicate what is considered bad faith or what sort of evidence would be sufficient to prove bad faith in order to be able to oppose the application. So that remains to be seen. It's likely that the parameters of bad faith will likely play out through the opposition board and on appeal to the federal court, and we'll have better clarification as to what those requirements will be. But as far as I understand, it's still fairly new, and we haven't had any opposition decisions just yet as to speaking as to the scope of the bad faith grounds. So stay tuned for that. One of the other interesting changes to opposition proceedings is now the ability to essentially challenge the initiating pleading, the statement of opposition, in an interlocutory ruling. Essentially, before if you are the applicant, before you respond by filing your counterstatement, intending to oppose to respond to the opposition, you have the opportunity, excuse me, to request an interlocutory ruling to strike down the opponent's statement of opposition, either in whole or in part. And you can do this on the basis that the statement of opposition has listed improper grounds of opposition, or that the grounds of opposition weren't stated in sufficient detail. For example, if they opposed on the basis of distinctiveness, if they lack of distinctiveness on the basis of third-party marks in the marketplace, if they haven't specified what those third-party marks are, that might be an opportunity for you to raise in an interlocutory ruling. Once the interlocutory ruling request has been made, the opponent will be given an opportunity to respond. But unfortunately, there is the opponent will be able to respond either by reply or they will have to seek leave to file an amended statement of opposition. I do note that when the timing issue for filing these interlocutory rulings are quite important. You have to keep in mind that these interlocutory ruling requests must be made prior to the filing of the counterstatement. And if you don't file it beforehand, then you are essentially restricted to making any challenges to the pleadings at the hearing stage. And just a word of caution, there's no automatic extension for filing the counterstatement. You have to request that separately. With respect to cross-examinations, there have been some developments. some of it spurred on by the COVID scenario which we're in, but it's been very helpful just generally. So in addition to allowing for video conference cross-examination during the COVID period, they've now extended that to just the default or preferred method for cross-examination generally. So this has been an excellent development for I think all parties involved. Previously, the requirement was that the affiant or the person being cross-examined had to attend physically in Canada, absent exceptional circumstances where they couldn't travel to Canada. Now that video conference is sort of the de facto standard for cross-examination, that has very helpful in terms of cost savings and also the selection of the appropriate affiant for the evidence being filed in the opposition. So that is a welcome change. And I am cognizant of the time here, so I am trying to give you the highlights. If anybody has any questions about any of the content that I'm speaking to or the content that Sanjukta or Kat has spoken to earlier, please feel free to send questions on to us, and we'll do our best to answer them for you, whether directly or via the webinar. And just a quick mention about the changes to submissions before the opposition board, both written representations and oral hearings, slight changes there. With written representations, they've just changed it to a sequential filing, so the opponent goes first and then the applicant will respond in a couple months' time, and that has helped just to balance things out to make things a little bit fairer. And with respect to the oral hearings, there's now an option to request attendance on a conditional basis, which is helpful if the party does not necessarily want to commit to attending the hearing if the other side is not also attending. So that is something new and helpful in my view. I do want to point out that the conditional requests have to be made within the specified time period. If you don't make a request to be heard, you cannot then attend, even if the other side has already requested the hearing and the hearing has been scheduled. So do keep that in mind. With respect to Section 45 proceedings, there haven't been a significant number of changes with respect to the scope of Section 45 proceedings. You can now request a non-use cancellation proceeding against all the goods and services covered by the registration or just restricted to a certain subset. The registrar also has a broader scope of discretion when allowing Section 45 non-cancellation proceedings to commence, or even the ability to initiate non-cancellation proceedings on its own initiative. Although, as far as I understand, there's no policy in place right now where they are actively looking at registrations to basically cancel for non-use. But we will see in time whether that becomes a standard policy for the office. The same changes to the order and timing for the written representations and oral hearings in the opposition proceeding have also been carried over to the Section 45 proceedings. I just wanted to make a quick note about use requirements in Section 45. As noted earlier, use is no longer a requirement to obtain registration anymore in Canada, nor do you have to put in the use claim in the application. However, use is still required to maintain that registration. All registrations are still subject to non-use cancellation proceedings after 3 years from registration. So keep that in mind. I also wanted to bring to everyone's attention an interesting development in case law regarding use in Section 45 proceedings. Over the past several years, there have been litigation and questions regarding whether or not use of a trademark with services in Canada required sort of the more traditional bricks and mortar operation in Canada, and whether or not services provided, for example, remotely online, which is much more prevalent these days, can be established even though there was no physical location or operation in Canada. This matter has been litigated in the lower level federal courts for some time, and there have been some differing views, perhaps, or divergent views on what should be acceptable. But an interesting development last year from the Court of Appeal confirmed that trademarks, use of a trademark with services may not necessarily require a bricks and mortar operation. In this particular case here with this Miller-Thompson decision, use of the trademark was in the context of hotel services. And in that case, there were no brick and mortar hotel operations in Canada. But the Court of Appeal found that when assessing the scope of hotel services, and you'll see in the slide here, the considerations that are taken into account when assessing the scope of a service, that it should be construed liberally and can encompass primary, incidental, and ancillary services, so long as a member of the public in Canada receives a material benefit from the activity in question. So in that case, hotel services could be broad enough to encompass things such as reservation services, booking and payment services online. So that is something to keep in mind, both in determining whether you or your client's use of the mark could be established in Canada through incidental or ancillary services, but also something to keep in mind when you are looking to commence non-use cancellation proceedings, to also look into perhaps whether the registered owner could sustain that registration on the basis of ancillary or incidental services. Just a quick couple of comments about changes that are still to come. These have received royal assent from Parliament, approval from Parliament, but the coming into force date has not yet been set. And this is largely due to waiting on regulations to still be put into place and other practices to be developed. Case management will be something that will be coming into force for opposition in Section 45 proceedings before the opposition board, which is definitely a welcome change. This will help to better manage opposition and cancellation proceedings, particularly if there are multiple co-pending proceedings at one time, pursuing at the same time. The form of that case management is still to be determined, so that's something that will need to be waiting patiently for. Confidentiality orders is another thing that is to be coming down in the future, which is also a very welcome change, although the form and the timing of that is still to be determined, but this will definitely be helpful when filing evidence, and those would be able to be kept under confidential seal, with only the relevant parties being able to access that and not on the public register. Cost awards are also in the pipeline to potentially come down for opposition proceedings. Right now, there are no cost consequences for commencing or cost award consequences being awarded by the opposition board for any opposition or Section 45 proceedings. But that will be something that is coming into force at some point. So keep that in mind. In the future, we will be letting you know when that comes by, and I'm sure there will be some notice ahead of time. The other significant change that could affect the practice is that leave will be required to file additional evidence on appeal of opposition board decisions to the federal court. Currently, leave is not required, and you can file additional evidence as of right, but sometime in the future, there will be leave required. Right now, there's no specific criteria for that leave, but this will be left up to the federal court likely to decide, and this will likely take on the same form for other requests in the federal court for leave to file new evidence. I'm cognizant of the time right now, so I'm just going to give you some of the highlights regarding the upgrades to the law and trademark laws relating to trademark enforcement. There have been a couple of developments regarding imports. One of them is a new provision for deemed infringement for imports in certain cases of clear cases of counterfeit products that were imported on a commercial scale. My apologies. There's now a presumption of confusion where the trademark is identical to or can't be distinguished from their essential aspects. This is helpful for trademark owners, particularly for counterfeit products, in that it helps to streamline a finding of infringement in your infringement actions. I do note that this could also increase the burden on some importers regarding gray market goods to prove the provenance of their products. There's also been a slight update to the border enforcement regime regarding counterfeit goods. As many of you may know, there is a regime in place right now where the Canadian Border Services Agency, the CBSA, has officers have the authority to detain suspected counterfeit or other pirated or infringing goods at the border, provided that the rights holder has filed the necessary documentation with the CBSA. Previously, it was only limited to imports that were coming into Canada as a final destination, but now that has been expanded to in-transit goods flowing through Canada's border onto, for example, the US market. So that is also helpful. Quick note about enforcement when it comes to the NIS classification. Classification, according to NIS, is, as discussed earlier, now a mandatory requirement. However, it will not be determinative. Overlap in the NIS classification will not be a material determination when discussing confusion. There's been a federal court case now that has clarified that as it was before, NIS classification will not be determinative whether the goods and services are similar. That would be a specific assessment, and that only forms part of the overall balance of factors when that go into assessing whether two marks are confusedly similar. And as mentioned earlier, there has been some development with respect to trademark use with services without bricks and mortar operations. So that has been a helpful development. Just a couple of quick points about changes that are still to come. Last minute here, I promise. These again have received royal assent, but no coming into force date has yet been sent. Importantly, there will be a proof of use requirement to enforce registered trademarks in the future. This means that you will have to begin using your trademark to enforce it within the first 3 years. So that is something that to keep in mind. Again, even though use is not required to obtain registration, use may be required to maintain that registration and possibly in the future to enforce that registration against third parties. So please keep that in mind. I already discussed that leave to file additional evidence on appeals from opposition board decisions could come into force shortly. And lastly, just a quick note, NAFTA 2.0, whether you call it the US MCA or the Canada-US-Mexico Agreement, NAFTA 2.0 called for Canada to essentially establish a system of pre-established damages and additional damages for trademark infringement. The pre-established damages, you could interpret that as statutory damages, and as many of you may know, under copyright, we've had statutory damages available for copyright infringement for quite some time, but the corresponding statutory damages for trademarks does not exist currently. We are limited to damages, potentially nominal damages or established damages, but currently the statute does not provide for a set of statutory damages. So this is a possible amendment to the Act, although it is not clear how Canada will be implementing that and whether they might take the position that pre-established damages can be met through judicial practice. It remains to be seen how we will deal with that, but it is an interesting development nonetheless. So that concludes my presentation. I'm going to hand this over back to Reagan. We are running a bit over time, so I'm not sure if we have any questions that have come in. Perhaps I'll let Sebastian or Sanjukta to speak to that. Notice the flurry of activity that was happening in the chat.
Thanks, Nathan. We had one question which was answered in the chat. Of course, everyone I think would be happy to answer any other questions you have. You can reach all of our panelists by email. Anyway, we are obviously over time, but thank you so much for joining us today, and thank you to our panelists. As we've mentioned before, it's our 100-year anniversary, so please anticipate some more programming coming up. So keep an eye on your emails and our LinkedIn. Thanks, everyone.